Recording.
Wonderful. Well, thank you guys for coming. I know this is a small group. I'd love it if you feel like putting yourself on camera, because that way you can wave at me and ask questions. And I want to encourage you to ask questions as we go. So my name is Leslie Orloff, and I direct, oops, hold on, my thing's not working. Make sure I get it changed. Here we go. There we go. I direct the National Immigrant Women's Advocacy Project at American University, Washington College of Law. And although most people around the country know me for the role I played in drafting VAWA and T and the U visas, I'm actually a family lawyer. I discovered back in 1985 or 82, I think, actually, that I was the only person who spoke Spanish in DC who knew what a protection order was. And that's where I started my career. I started representing people in all kinds of family court proceedings who were immigrant victims. So I'm happy to be here today and to talk to you about some of the things that, some of the special issues that you'll run into, and to try to build your skills and your tools about things to be prepared for when you're working with foreign-born victims. Mostly victims, I'm talking about victims of domestic violence, sexual assault, child abuse. I've been doing training for the last 7 years with a national team of judges. So we've been doing a lot of judicial training, and the materials you'll see are similar in way to some of the materials we use for judicial training. So by the end of the training, you'll be able to develop family court litigation strategies that will inform judges about immigration law from a perspective that's legally correct. There's a lot of misinformation out there, and you'll be able to counter attempts by perpetrators to gain advantage in family court by often using legally incorrect information or trying to convince the court that, for example, it doesn't matter that he was an abuser, he should get custody because he's a citizen and she's not. Things like that. You'll be able to use VAWA Confidentiality federal laws to prevent discovery of the victim's immigration case in state court proceedings, and seek and obtain U visa certifications, T visa declarations, and special immigrant juvenile status findings from state family court judges. I'm going to start, I know you guys are working in domestic violence, have lots of domestic violence cases, but I'm just going to start with a little bit of data talking about some of the unique power and control dynamics that happen in immigrant families. Usually when there's a spouse or partner that's a U.S. citizen or lawful permanent resident, and then one of the other spouse is foreign-born. And one of the things that we see, particularly in marriages, is that although under immigration law, spouses can file papers for people married to U.S. citizens or lawful permanent residents, the spouse can file papers. When the spouse is an abuser, over 70% of the time he doesn't file, or she doesn't file. And there's a mean delay of almost 4 years when they can file and do file. We see, and this was the data that we actually took to Congress when we wrote the Violence Against Women Act immigration provisions in 1994. And so there's about 65% of the cases you'll see this kind of power and control dynamic going on. And you're going to see it in family court cases as well. We also know that among immigrant women married to U.S. citizens, the abuse rate in those families is quite high. It reaches almost 60%. And what's interesting is we saw that citizen spouses in particular, and lawful permanent resident spouses have been, as immigration enforcement goes up and fear of immigration in the media, people talking about it and anti-immigrant sentiment, all of that, we've seen a dramatic drop in the willingness of immigrant victims to file self-petitions, to file the immigration cases. These are people who are married to U.S. citizens and lawful permanent resident, have a clear path to legal status, but they're afraid to file the immigration case. Now, interestingly, in this same time period, we didn't see a fall off in willingness to seek protection orders. And that's because in places where the courts have, you know, a reputation for treating people fairly, and lawyers play a big role in letting clients know it's safe to go to court, you know, and that they'll be treated fairly by the judge and the judge will listen to them. That despite the fact they might be afraid to seek immigration relief, they are still willing, with support from lawyers and advocates, to go to family court. So that's what we're seeing recently. The other thing that's important, and I put this slide here because particularly in family court cases, you see this power and control dynamic happening in domestic violence cases all the time. And one of the things that happened is that a key tool of that power and control is immigration-related abuse. You know, you can't leave me, I filed your papers, or I'll withdraw your papers, or I'll turn you in if you leave with the kids, stuff like that. And what we found is that that type of abuse it coexists with physical and sexual abuse. It's 10 times higher in physically and sexually abusive relationships than it is in emotionally abusive relationships. So it's not something, like when you see it, I mean, I'm old, so I will give you an old time example. When you see it, it's like the old cut telephone cord. You know, back in the old days, if police arrived on the scene and there was a cut telephone cord, it was corroborating evidence of domestic violence because he was trying to cut her off from communicating, from calling for help. Immigration-related abuse is similar in that respect. The other thing that we see in these relationships is that, perpetrators, and you'll see this in your family court, they're actively involved in trying to get victims, either in retaliation or otherwise, reported to the Department of Homeland Security so that she's removed, so she can't win her protection order, custody, or divorce case. And when those cases are going on, you see more of these power and control dynamics happening. So I'm not going to spend today a lot on immigration relief, other than to talk about kind of the major forms so that you can recognize them in your cases and you can identify, oh, thank you very much. Okay. So that you can recognize them in your cases when it's come up, and identify victims that could qualify for immigration relief. Because one of the things we also know is that when immigrant victims begin the process of filing a VAWA self-petition, a U visa, T visa, or get, you know, a child files for special immigrant juvenile status, etc., their willingness and ability and comfort level in using the court system and fully participating in family court goes up. So they're more comfortable because they're less afraid. And so this was developed by the Department of Homeland Security, and it's a tool to help screen and to tell the difference between the VAWA and the U and the T. We have on our website the materials, and when you get this in a PDF, it's actually live. So if you, I don't know if you can see my cursor, if I come over here, hold on. Can you see the cursor on the screen? Yeah, okay. So if you click on this button on the PDF, it goes to the DHS website with the forms. If you click on the word U visa on the PDF, it goes to the PDF, the Department of Homeland Security webpage that discusses each of the programs. So it's a really good tool to use. We have it also in multiple languages. It's just if they click it in multiple languages, they still end up on an English webpage. So, but this is a good summary, and I'm going to go over, and so there's a wide range of different kinds of immigration relief that are available to help crime victims. The hardest one to get here is asylum. So we're not actually going to be talking about asylum very much. It's more focusing on these other remedies that are tied to domestic violence, sexual assault, child abuse, human trafficking, things like that. So we're going to start the webinar kind of looking at the major forms of relief so that you understand kind of the difference between them. And I'm going to do it fairly quickly because I want to get into the nitty-gritty about what this means in family court. So So the first one is the Violence Against Women Act self-petition, and this is when the abuser is a U.S. citizen or lawful permanent resident, either a spouse, a former spouse within 2 years of divorce or death, a parent, a step parent. So that's another issue, is that under immigration law, step parents and parents are the same. So it's very different from family law in that respect. So if you have abuse by a step parent, that's sufficient for VAWA self-petitioning. Or it could be an adult over 21-year-old. In elder abuse cases, it could be an over 21-year-old U.S. citizen son or daughter, and that's the abuser. They have to, there has to be some period of residence together, but it could have been 2 days. There's no quantity required. And they have to show that they're a person of good moral character, which generally means they don't have a criminal history. People with criminal histories can get violence against women, this relief, but it's a little bit more complex. But generally speaking, that's what they're looking at with good moral character. The marriage has to be a legitimate marriage. It has to be good faith, which means they didn't only get married for the immigration papers. And then there's a protection from deportation called VAWA cancellation of removal that has similar requirements. And if you have a case where the abuser actually filed papers for her, you might see a client who says, I can't divorce, I have to stay with him for 2 years or he won't sign my paper. That is a sign that there's a battered spouse waiver case potentially, and that allows the victim, same elements of proof essentially, that allows the victim to leave the relationship, get her full green card, and without waiting 2 years and without the perpetrator's cooperation. So it's another form of immigration relief. And what's interesting here is the definition of domestic violence under immigration law is battery or extreme cruelty. That definition, is broader than your state protection order statutes in Maryland, because it covers forms of abuse that are not criminal or that wouldn't be enough to get a protection order in Maryland. So can you anybody can give me examples of things you think might be extreme cruelty? And you can just unmute yourself and talk or type in the chat if you'd like. And Gwen, you'll have to read the chat because I can't see it.
Yep, I'm looking at it right now.
I'll take a sip while we're doing that. You seeing anything?
No, not right now.
Okay. So, and feel free to, unmute yourselves and talk. I'll keep going and then and ask questions or anything as we go. So, this is essentially the kind of checklist of examples of forms of extreme cruelty that it actually comes from for-cause divorce law and human rights law that the Department of Homeland Security looks at when they're trying to define extreme cruelty. Raise your hand if you've had like domestic violence training. Anybody? Does this kind of look like something you might have seen before? It's usually a different shape. Right, smiles. It's round. It's usually round. So this is essentially what they're using is an immigrant form of the power and control wheel when they're deciding the case. So it's important to understand that if you've got a divorce or family law case where you might not yet have or yet know about physical or sexual abuse, if these types of behaviors are happening, this person could qualify for a VAWA self-petition or a U visa. And what's interesting is so that it has two elements. There's the battering crime. So battering includes, from an immigration perspective, all the forms, not only the actual physical abuse or threats or use of a weapon or sexual assault or stalking, but attempts or threats for these actions as well. So those, just as the attempted sexual assault or attempted use of a weapon to harm somebody would be a crime under state law, it's considered battering under immigration law. And then all of the types of things that you'll see in your family law cases related to coercive control you know, those elements, those kinds of, those factual elements that you'll see in your family court cases would also be super important in the immigration case, and they're sufficient for immigration protection. So things like, you know, the whole pattern, of course, creating vulnerabilities, exploiting vulnerabilities, wearing people down. And this checklist of coercive control can be really helpful in putting together your family case in a contested divorce or contested custody to show the court the perpetrator's behaviors. Any questions so far on this? Okay. So the U visa, so that covers, that only helps people where you have essentially a parent-child or a spousal relationship. So what about everybody else? So you have cases that will be perpetrators where you have an intimate partner relationship, or there's a stranger or somebody who, you know, somebody might be a victim of another form of criminal activity. And so basically, the U visa list is quite broad. It covers a broad range of criminal activity. It covers, but 75% of cases nationally are domestic violence, sexual assault, child abuse, human trafficking, and stalking, and those kinds of crimes. It also covers different kinds of felonious assaults. There are kidnapping-related crimes, extortion, witness tampering, things like that. And a victim has to have been, either they have been helpful, or being helpful, or likely to be helpful in the detection, investigation, prosecution, conviction, or sentencing of a criminal activity. That can include going to get a protection order. Not filing a police report, but going to get a protection order helps the court detect the domestic violence in the family. Taking your child and participating in the child welfare proceeding is helping the court detect the child abuse. Talking, you know, pleading and putting in evidence of domestic violence in a custody or child abuse or a divorce proceeding helps the court detect the domestic violence or child abuse. So that's sufficient for a U visa. The victim also has to show substantial harm as a result of the physical activity, physical or mental abuse. And this all of this abuse has to have occurred in the United States. But that's a much broader category. Other thing to note is the VAWA self-petition, start to finish, roughly 18 months, you know, to approval, which means protection from deportation, work authorization, driver's licenses that are recognized by the federal government, all that stuff. U visas, it's 4 to 6 or 8 years to that point of approval where you get work authorization, a driver's license, formal protection from deportation. So much slower process. You don't actually get the visa for another 11 or 12 years. So it's a really long process. Special immigrant juvenile status, there are a lot of cases you'll see where there's an overlap between the mom is abused and the children are abused. So like in a family relationship, you have abuse of the child and abuse of mom. Those mom might be filing for a U visa and the kids could be included in her application, but then they're stuck in that 6 to 8 year wait. If the children are abused by their parent anywhere in the world, so this remedy has no restrictions for abused, abandoned, or neglected children. It helps them where the abuse, abandonment, and neglect happened by one of their parents anywhere in the world. So, and it doesn't have to be all of them. It could be just abuse or just abandonment or just neglect. And those are cases where you can go to you have to go to state court and get findings that the child was either abused, abandoned, or neglect, and we'll be talking about that and the role family court judges, lawyers can play in that. And that's a process that's at the longest 3 years. Most cases are decided within the first year, and kids get their green cards, lawful permanent residency and green cards within this period of time. So it's quite fast for children compared to the other remedies. You could also have victims of human trafficking. And sometimes as family lawyers, we think, you know, that we don't see this, but we actually do. And we're going to talk about that in a minute. But basically, it's sex or labor trafficking involving a victim under the age of 18 or an adult who is subject to force, fraud, or coercion in the context of either sex or labor trafficking. They have to be physically present in the United States. They have to comply with reasonable requests for helpfulness or assistance in the investigation or prosecution of trafficking. And the reasonable request compliance requirement has some exceptions for children and some exceptions for people who can't comply because of trauma. And this is, again, quite fast compared to the U visa. And they don't run out of these visas. So identifying trafficking in family court cases can be really helpful. Any guess on what some of the typical ways you actually might see trafficking in your family court cases? Anybody had any that you could think of? Any scenarios? No? How about, have you ever had a case where the husband forces the wife to work for his family business and doesn't pay her? Human trafficking, labor trafficking. I mean, that's the most common one. Also, in some domestic violence cases, he might force her to have sex with other men. That could be sex trafficking, depending. What's interesting about trafficking is that, I don't have it on the slide, but you don't have to make them cross the border. Somebody could be in the United States and end up trafficked because the trafficker is playing a role in coercing her, like in trapping her in the relationship, or so that she can't move, or there's consequences to it. So they're procuring essentially her services is the way to think about it, whether it's sex or labor. So these can come up, and if you have facts, certainly the facts where if you ever run into a case where he's forcing her to work and not paying her, that's the easiest trafficking case in that respect. So it could be, call us and we can help you with technical assistance to walk through it. Immigrant victims involved in custody or divorce cases or protection order cases will qualify often for one of these forms of relief. And this gives you a summary. You know, if it's a domestic violence case, it could be a VAWA self-petition. It could be any of those things. A U visa, there's broader crimes, and trafficking is this kind of thing. Benefits, survivors who apply for these remedies, they get protection immediate. As soon as they file, they get some immediate protection from deportation through VAWA Confidentiality, which we'll be talking about later. They can include family members in their petitions. They have a path to legal immigration status and financial independence from the perpetrator. And depending on the kind of case, they can include other family members in the application. So if you're a VAWA self-petitioner, you can include your children, any of your children that are undocumented in your case who are under 21 years old, and under 21-year-old victims of child abuse can include their own child, but they can also include their parent in the application. Also parents, so you might have an immigrant parent who's not abused themselves, but they have a child who's abused or a stepchild who's abused. They also qualify for self-petition in order to protect the stepchild based on the stepchild or the child's abuse. U visa victims can include a broader range, so it's their spouse, their children, their parents, and their unmarried siblings if they're under 21. If they're over 21, it's the same, it's spouse and children. And special immigrant juvenile status children can include anybody. So they can't even include their non-abusive parent. So the point is, it's a remedy just for the kid. So to give you an idea of how this works, I'm going to read a quick hypo and then have you answer some questions. So get ready to use the chat box a little bit. So Clara met Eduardo, a lawful permanent resident, when he came back to his hometown to visit his family in El Salvador. Eduardo started dating Clara, who was raising her 9-year-old son, Miguel. After Clara became pregnant and gave birth to a baby girl, Lupe, so the girl was born in El Salvador, Eduardo decided to bring Clara, Miguel, and Lupe to live with him in the United States. When they arrived in the U.S., Eduardo took Clara, Miguel, and Lupe's passports and became physically and sexually abusive of Clara and abusive of Miguel when he tried to protect his mother from Eduardo's abuse. Eduardo also physically beat Lupe when he said she misbehaved. Within a year following their arrival in the United States, Eduardo forced both Clara and Miguel to work for his family business and never paid them for their labor. One night when Miguel was 13 and Lupe was 5, Eduardo's rage led to severe beatings with the belt of Miguel and Lupe. When Clara intervened to protect the children, Eduardo strangled her until she passed out. Neighbors called the police. Clara talked to the police when they arrived. The police arrested Eduardo for attempted murder and child abuse and took Clara to the hospital and placed the children in the care of the state. So, what forms of immigration relief might Clara qualify for? So I'm going to show you the next slide. And we can talk about it. So does she qualify for a U visa? Does she qualify for a VAWA self-petition as the parent of Lupe, or a T visa, or all of the above? Raise your hands if you think it's A U visa. How about B? C?
We have a D in the chat.
We have a D in the chat. D is right.
Yeah.
All of the above. Excellent.
Right.
Exactly. She's a U visa because she was strangled. She's a VAWA self-petitioner because she's the parent of a child who was abused by that child's other parent. Now, the issue here is there's no marriage. If there was a marriage, if we knew there was a marriage, then she could be a VAWA self-petition as the wife of Eduardo. And T visa because he forced her to work. So it's all three. Okay, so let's look at what Miguel qualifies for. So choices are VAWA self-petition, U visa, T visa, SIJS, or two of the above. I made this a little one harder. Anybody have any guesses?
E.
So E is one choice. Yeah? Okay, E is correct. So now which two? You can unmute yourself if you want and talk or type, whichever you prefer.
A and D.
Okay, so he definitely qualifies for D. No, he doesn't qualify for A and D. Those are the two he doesn't qualify for, and I'll tell you why. The reason is there's no marriage. He would be the stepson. So both A and D require a marriage. U and T do not. So he qualifies because of the beatings, he qualifies for U, and because of the work, he qualifies for T. So that's the way to think about it. So you always have to look, is or isn't there a marriage? And is there a step, that creates a step-parent, stepchild relationship? Now, Lupe can self-petition because it's her dad that abused her. That's how it works. So why is this important for family lawyers? It's important because in your family court cases, judges can make findings. They can say, so for example, they can find that they're married, if in fact there was a marriage, and they can make those kinds of findings. They can establish a parent-child relationship. Let's say a child was born out of wedlock and you have to prove that Lupe's father is Eduardo. And so those kind of evidence in family court case can be super helpful in the immigration case. They can make findings of the abuse that occurred. Going back to the story, the beatings or the abuse, having those kinds of findings in the family court case can help with all of these forms of immigration cases. And that they can and should, anytime you're dealing with a case where you might want to use the court order for immigration, it's always good to cite your state law, because think about it, if you're an adjudicator sitting in Nebraska deciding a U visa or a special immigrant juvenile status case from 50 different states, you don't know their state law. And if you tried to look them up, you'd probably get them wrong. So it's good to include the state law in the orders. And courts and Congress created a special role for state court judges in certain kinds of proceedings. So they can sign T and U certification requests, and we'll talk about that. in order for a child, and U visa is really important because they have to get a certification from a government official, and judges are one of the government officials that can provide that certification. And that's a prerequisite to filing, whereas in T, it's not a prerequisite to filing. It's helpful evidence, but not required. But on special immigrant juvenile statuses, you have to have findings from a judge in order to be able to file, and we'll talk about how you get those from state court judges in a little bit. And then these judges also can rule on discovery motions that keep the perpetrator from being able to get a confidential file that the federal government has that he can't get from the federal government. He could only try to get it through a state court judge who doesn't know better. And so we'll give you the law so that the judges will know better if this comes up in your case. So that's why it's important for that. What am I doing here? So now what we're going to do is go into talk about just a little bit more about the U visa, and U visa certification by judges is what we're moving into now. So we talked about the elements of the U visa. You have to be helpful and suffered substantial harm, etc. And so these are the criminal activities. So they're very broad. So if you ever have a case in which any of these things are occurring, and you have an immigrant victim, that victim could qualify for a U visa. And if any of these criminal activities are part of your family court case, and you make it part of your custody or your divorce or your child welfare, your protection order case, then the victim could ask the judge at the end of the proceeding for a certification. And the judges who can certify it's quite broad. It's judges, it's magistrates, commissioners, referees, anybody who has judicial authority to do decision making, you could ask for a certification. Judges need to amend the certification form, and I'll show you how they do that in a minute. And judges do certification based on detection in either a family case, a juvenile case, a civil case, or a criminal case. And that detection can happen from what they see the victim doing. She's coming to, she came and got an emergency protection order, came back to court to get the full protection order. She filed pleadings, she testified, she came as a witness, she attended motions hearings. All of that stuff is helpfulness. She might be working with the prosecutors in a criminal case, but it's not required. It could be criminal, could be civil. And then in criminal cases, where they're involved in conviction or sentencing or testimony, judges can certify as well. So the helpfulness is the prerequisite to certification, and helpfulness can be either in detection or investigation, and the other investigation, prosecution, conviction, sentencing. It can be any of those. Doesn't have to be all of them. A judge can certify. Let's say you have you're working with somebody and you're going in to get a temporary protection order, and you get through a temporary protection order, but the perpetrator flees and you're never able to serve him. They can't serve him. So you don't get a permanent protection order. But in the temporary protection order, the victim told the court about, or brought in and showed the court a copy of a police report they made. The judge can certify based on observing the copy of the police report and the fact that she sought the temporary order if you're in a jurisdiction where your local police who issued the report won't certify. So you can go to the judge for certification, even, as long as they can detect that she was trying to be helpful at some point in time. So what happens is to get certification, you have to show some kind of helpfulness. After getting the certification and the victim files, then the victim has an ongoing responsibility to provide assistance or cooperation reasonably requested by law enforcement or prosecutors. So if you have a criminal case, she's supposed to help them. But there's an exception, and that is, how many of you work with domestic violence victims or sexual assault victims who always follow through from the beginning to the end and never change their mind? It doesn't happen, right? It happens, they always change their minds. They often change their mind. And when we wrote the statute, we knew this. And so we wanted victims to be able to get their visas and still, so we created a standard saying that they couldn't unreasonably refuse to cooperate. And in the regulations, it also says the requests have to be reasonable. So requesting that, when a prosecutor tries to mandate that a domestic violence victim testifies against her perpetrator and subpoenas the witness, even though the victim doesn't want to come, and the victim doesn't show up, one could argue that that wasn't a reasonable request of a domestic violence victim who's still living with her perpetrator. And so she can make that case to DHS. So there's a way you can get certification even when victims kind of go back and forth over time in their cases. The evidence, by the way, is that 70% of the U visa victims over time actually do cooperate, and 29% of them want to cooperate, but the case isn't going forward. So it's really high levels over time, but that doesn't mean they go back and forth. So the kinds of evidence, you'd have evidence of helpfulness present in all these different kinds of cases. And here's some examples when we teach judges of the various different ways victims in civil court cases can show helpfulness to a court. Appearing in a protection order, testifying, pleading, providing evidence, submitting copies of evidence, showing up at hearings, all those kinds of things. So why would victims seek a U visa certification from a state court? Is it because the only justice system contact they've had was custody or protection order or child welfare case or employment case? Is it that they called the police for help and the police showed up and didn't provide language access so they couldn't communicate at the crime scene? Could it be that the judge observed the victim's attendance and participation in a criminal case, or all of the above? So if you could type in the chat, and Gwen will tell me what you
have D.
Yes, it is D. That is correct. It's all of the above. There's lots of ways and reasons why they might go to a state court for a protection order, for a U visa certification. And the U visa certification itself just tells the certifier, the DHS, that the certifier, in this case the judge, believes that the victim was a victim of criminal activity, that they've seen from what's happened at court that the victim has knowledge of the criminal activity, and that the victim was helpful. I mean, judges are almost never, they're usually judges are certifying on helpfulness usually that they've already seen. They could also certify on likely to be helpful, but they generally don't. It's usually a case that has been before them where they've seen the client do something. And for T visas, they might have observed that the victim has complied with reasonable requests from the prosecutor because they came to court in a criminal case. Helpfulness is met whether or not there's a criminal. It doesn't require a criminal case. It doesn't. The perpetrator could have fled. Maybe they decided not to prosecute him. Maybe the victim isn't the best witness and the prosecutor doesn't need them. Even when the perpetrator, you could actually have the victim being dead and then the indirect victim being their spouse or child. And it doesn't require that the case, because the case results in a conviction. I mean, the goal here is to get victims to come forward and use the system, is what this is about. So the, the process for filing a U visa, it takes many years. And these blue squares are points at which they do background checks. So if you're working with victims, they check the criminal history essentially of the victim at all of these different points in the procedure. It takes, as I said, 4 to 6 years to get the initial adjudication, which gives them work authorization, real protection from deportation, full driver's license, et cetera. In Maryland, they'd get at this point, I have to look, we'll tell you the benefits they get. U visa victims get less benefits than VAWA self-petitioners. But this is how the process, and this is useful to explain to a judge in case they think, oh my God, I'm gonna sign this certification and I'm gonna give them their visa. And this is a great tool to show the judge, it doesn't really work that way. You're just like opening the first door. That's what the certification does. And then the victim has to go through this entire process. So that will calm the nerves of a lot of judges. when the judges sign a certification, they don't sign, judges, when they read this language in the form that says, I sign based on investigation or prosecution, judges will, first thing they'll say is, I don't investigate or prosecute. And DHS basically says they can amend the form. So the judges cross out investigate or prosecute, and they can put in, based on my ruling in the custody case, based on my ruling in the protection order case, based on my finding probable cause, whatever it is they did, they can just basically say, based on this, see my attached order, and then they can cross out the last line, because the last line says, if the victim refuses to cooperate in the future, I'm going to call the USCIS and tell them. And judges under judicial ethical rules can't track victims. They need to be objective and available should somebody need to come back to court in the future. So judges can make those amendments to the form, and when they do, the forms are still accepted. We have a toolkit for judges. We have a new one I just put up yesterday. So we now have one that covers U certification and T visa declarations as well. But it's a really good tool that you can share with a judge who might be considering certification. Any questions about U's before I move on to special immigrant juvenile status? Questions about U visas or anything? Everything's good? Want to take a breath or something like that? Okay. Okay. If you see anything in the chat, Gwen, just interrupt and tell me, okay? You can wave at me. Okay, so now I'm going to go on to the other form of relief that Congress wrote state court judges into the statute. And this is special immigrant juvenile status, state family court judges into the statute. So special immigrant juvenile status is a form of immigration relief. It's humanitarian. It's available to unmarried children who cannot be reunited with one or both of their parents because that parent abused, abandoned, or neglected the child. You have to go get state court findings, and those 3 findings that the court has to make in these cases are that they make those findings using state best interest laws regarding the placement of the child. So you have to, the way to think about this is you have to have abuse by a parent and then some court placing a child with somebody, okay? It doesn't have to be a parent, it doesn't have to be the state, but they basically make a placement decision or a custody decision, and then they include the findings that regarding the child, and we'll go into what those are. And that it's really important to tell courts that they're not giving the child special immigrant juvenile status again, they're giving them the prerequisite findings that allows the child to file the application with the Department of Homeland Security. And it's a required piece of evidence. And I'll go into the findings in a minute. Under Maryland law, so this is what's really interesting. You could have a child who is abused or abandoned or neglected by their parent in China, in El Salvador, in Papua New Guinea. It doesn't matter, wherever, Mexico. When the court is asked to decide whether the child was abused or abandoned or neglected, they're taking Maryland law, the definitions of abuse, abandonment, and neglect under Maryland law, and they're applying them to the facts the child experienced anywhere in the world. So they could have been abused in Maryland, but they could have also been abused in El Salvador. And the judge doesn't have to figure out what El Salvador law is, they're just using Maryland law definitions. So for example, in Maryland and in many, many states, where do you find your definition of abandonment? It's actually in the UCCJEA. It's in the jurisdiction statute. But if you look at Maryland law, section 5701 has, or no, yeah, 5701S, where they're talking about neglect, the way neglect is defined with no proper care and attention could be abandonment. So you might have an abandonment case that fits in both places. What's also interesting in Maryland law is that there are things, you have a forced marriage law, you have a reckless endangerment of a child law, and then you have a domestic violence law. What's really important is when kids, when what happened to the child would be covered by any of these three laws. When you're asking for your findings, you don't want your court to, every single one of these three laws includes these elements. So what happens is forced marriage includes abuse, because it includes sexual abuse. Reckless endangerment of a child is more than neglect. So it'd be better to cite the neglect statute in the order that the court writes than this, because if you cite the reckless endangerment statute, then the lawyer who helps the victim in the SIJS case is going to have to argue with DHS about whether reckless endangerment is neglect or similar. But you don't have to worry about it because neglect, this definition of neglect is contained in the reckless, it's within it. It's a subset. So you want to, for SIJ, get the judge to cite the neglect law and the child endangerment if she wants, but you don't have to. The proceeding may be a child endangerment proceeding, but the finding should be a neglect proceeding. And similar with domestic violence. You could have a domestic violence proceeding, which includes in Maryland child abuse, but it'd be better to find the child abuse for the SIJ, which is why I do this. Any questions about that? Does that make sense? And it's largely because the adjudicators are looking at the abuse, abandonment, and neglect decisions. And you don't want to, many of them aren't even lawyers. So you don't want to make them try to decide what's included in what. And they're more likely to deny the kid's case if you cite these laws than if you cite these laws, which is why I gave them to you. So what happens is so these are the findings. The court has to find jurisdiction to issue the order, some kind of order of placement or custody of the child, and that could be with anyone. A state, next of kin, a non-abusive parent, doesn't matter. But they make a placement or custody decision. They also have to find that it's not in the child's best interest to return to the child's home country. Now, generally, what this is what they do in a custody case or abuse case. They're going to go through anybody who could potentially have custody of this child, you know, that they'd have to serve in the proceeding. And they're going to decide that it's in the best interest. So I'll give you a hypothetical. Let's say dad sexually assaulted his daughter in El Salvador in the house of grandma, his mom. And and some aunt smuggles, you know, or not smuggles, takes the child from El Salvador and brings her here to reunite with mom in the United States. And mom's in Maryland. So mom's going to sue dad for custody. And the court is going to look at, under Maryland law, they can look at mom, dad, and grandma, right? Maybe somebody else. But let's say it's mom, dad, and grandma. And they're going to go through looking at your best interest factors, and they're going to decide it's in the best interest to live with mom. If it's in the best interest to live with mom and it's not safe to live with dad or grandma because dad abused and grandma didn't protect, you're done with the best interest. It's not about country conditions in El Salvador and gangs and drugs and anything. It's about there's no safe placement for her. And that's the kind of thing that a family court judge gets. It's their bread and butter. It's what they do all the time. And as lawyers, keeping this to those, showing the judge, helping the judge think about it this way is really the most effective way to do these findings. And you can see that they're not different from what you're doing as family lawyers anyway. And then once the court decides that it's not safe to be with dad and mom's in the best interest, then the finding that reunification is not viable due to the parent's abuse, abandonment, or neglect is easier to reach for the court, and they have to make that as well. Now, you can make this finding of this last finding of reunification not viable as long as the court isn't, what that means is the court's not inclined to give full custody to the abusive parent at this time. They can see each other, there could be supervised visitation, there could be unsupervised visitation. None of that means, it means, is the state court going to award full custody to that parent in the foreseeable future? Which in most of your cases, once they've issued an order saying they're not getting custody, they've abused the child or whatever, they're not, getting to this viability isn't that difficult. Courts can make these decisions in delinquency, dependency, paternity, adoption, custody, protection, or all kinds of procedures. They apply their same procedural rules, so same service of process rules as in any other family court cases, and they file their state service and jurisdiction procedures. They apply these best interest factors, which are your Maryland factors, to the case. And they apply, it's the same as any other custody case or placement case in that respect. This is just some more details on the reunification of the parent with the home country, which I already talked about. If you have a case where it's a little bit more complex, you can I have a tool for you that talks about the VAWA extreme hardship factors, which do a comparison of the support and services the child is getting here versus what they'd have in the home country. You can walk you through that if it's a case where you think you need it. And that, as I said, it doesn't require that there's no visitation. It just needs to be a final order under the best interest that's appealable. And so when we talk about this, in one of these cases, so Clara has come to state court, you're representing her, and she's now seeking these SIJ orders. And in which of these proceedings would the court not be able to make the SIJ findings for Lupe or for Eduardo? So is it the protection order case that grants protection order and custody to Clara? Is it a custody case bought by Clara? Is it the criminal prosecution of Eduardo? Or is it the child welfare case in which the court made findings that Eduardo abused the children and gave Clara custody? So in which of these could they not issue SIJ? Gwen's going to look at your responses and tell me. You're muted, Gwen.
Yeah, I don't see anything right now. C?
C is correct. C is the correct one. So the only one of these cases where they couldn't issue SIJ findings is the criminal prosecution of Eduardo, because they have no jurisdiction to do a placement of the child, which is the issue. It has to be somebody who can place the child with somebody, and that wouldn't happen in the criminal case. It might happen in a child welfare case, or it might happen in a neglect case, or it might happen in a protection order case or a custody case, but not in a criminal case. Perfect. Best practices is to actually, judges are encouraged to include these orders, these findings in whatever order they're issuing. So if you're in a custody case or a divorce case or a child welfare case or a protection order case, you're going to want them to not be separate, but part of that court order. So, and have the judge actually explain and connect the dots for the adjudicator, saying, I'm finding this abuse, and include the details of the abuse in the order. And we have, if you're working on a case, we have a really good webinar we recorded for judges on how to do orders that we can send you to, and you might be able to even share with the judges. Any questions on special immigrant juvenile status findings from judges? Going, okay. Okay, I know this is a lot of information, but appreciate your attention and your time. So now what we're going to move on to is discovery, essentially. I'm going to talk to you about a little bit about once a victim, if you go back to that first chart that you remember seeing, in a VAWA self-petition, in a U visa case, or in a T visa case, once a victim starts filing the case, they get what's called federal VAWA Violence Against Women Act confidentiality protection. And that protection does three things. It bars the ability of the Department of Homeland Security to rely on perpetrator-provided information to harm the victim. So if perpetrator calls up and says, my wife is going to be showing up in courtroom X for a protection order on such and such a day, go get her, she's undocumented. If they go into the system with her name, they'll see she's got a VAWA self-petition. They won't see this, they'll see it's a red flag case, which is hands off for victim protection. So if she's got the immigration case filed, it will red flag that case and make it very complicated and potentially make the enforcement officer who tries to show up at your family court fined for $5,000 or subject to job sanctions if he shows up, if he responds, because he's not supposed to respond to these calls. In addition, there are certain locations that are protected. So immigration enforcement officials can't show up in family court to arrest a victim under any circumstances unless they get like the head of their agency's permission for some unusual reason because they think mom's a terrorist or something. It's very unusual. But the reason that's true, and I have whole trainings on courthouse enforcement and what this means. But we're going to focus on the last one, which is the non-disclosure provision, which has to do with the files and the existence of the files, or the fact of the filing at DHS being protected. So what happens is that the VAWA confidentiality laws, the federal laws, prohibit disclosure of any information about the existence of the VAWA T or U visa application, about decisions made in the application, about information contained in the A file, which is the actual physical file at DHS, and anything contained in that file is not discoverable in a family court proceeding. And that disclosure is prohibited to all persons, not just the perpetrator. So what happens is that in family court cases, nothing's discoverable. Not a VAWA, not the self-petition, not the U visa, or nothing about the case, etc. In a criminal case where you might have Brady in play because of criminal discovery laws, the only thing that's discoverable is the certification itself, not the whole case file, because the case file isn't in the custody or control of the prosecutor. And in civil cases, similarly, everything's protected in the civil employment cases, except for up and through the point where they're trying to determine damages, where there might be something, they might have to prove in order to get damages some of the abuse or something else. But generally speaking, judges would not need to, even in a family court case, review the file to see if they could release any of it. And this is the case law. We have the case law on this. This is, there's an exception, a judicial exception to the VAWA confidentiality rules that applies to the victim's immigration cases. It doesn't apply to state court cases. Despite the perpetrator's right to compulsory process, there's been a Sixth Amendment challenge to this, and the court has ruled that the information is absolutely privileged. And they've said that the primary purpose, it protects everything unless the case is denied on its merits, and that the primary purpose is to prevent disclosure of confidential materials to the accused batterer. And in a family court case, that's always who's going to be seeking it, is because it's the other side, and the opposing side is the batterer, and the idea is for him not to get this. The language in this Connecticut case is also super helpful, and they basically say that it's basically immigration-related abuse for him to he's trying to interfere with their immigration case, which is barred by federal statute, by discovering this information. So it's really good. We have tools for judges, all kinds of tools for judges. So if you have a case, Gwen, what we want to do is make sure that all of our judicial tools on VAWA confidentiality are included in the materials we distribute. I think they are, but we'll double check.
Okay, yep.
And we'll have a lot of materials on this for you. Any questions about VAWA confidentiality and discovery, or anything that comes to mind? Anybody? Okay, feel free to write them in the chat as I talk if you'd like. Okay, so the next thing we're going to do is we're going to move on to talk about so we've talked about the three ways in which courts, the immigration law, either you're asking the judge for something the victim needs for an immigration case, or the judge has to make findings for the child to get. So the Congress required state court judges to make findings so that the child gets the findings they need to file for special immigrant juvenile status, or where immigration law and family law intersect because it affects how courts are supposed to rule in discovery. That's what we've done so far. Now we're going to shift over to one of the things that we've seen is that as in times historically, when there's greater anti-immigrant sentiment in the country, perpetrators of domestic violence and sexual violence, but domestic violence in particular and child abuse, elder abuse, are more likely to waltz into the state court case and try to essentially lob immigration issues in the middle of the state court case to confuse the judge and to kind of derail the proceedings and to gain advantage for themselves. And so what we're going to do is talk about some of those tactics in the case law and how you can be prepared to fight that off. So one of the things that's really important, this is social science research we did, is that in these cases of immigrant victims, what we found is that when you compare immigrant victims who started to file protection orders in family court case or who started the immigration case, who've actually started working with lawyers and started to use the system, we see a significant drop in the co-occurrence of child abuse in those immigrant families. That protecting mom and mom being able to start getting protection really does protect kids from future child abuse. It reduces the co-occurrence. It reduces the likelihood that the children might be, that the batterer might threaten to the children, and victims are a third less likely to have the perpetrator snatch the kids. So there's a real protection that happens here when victims start using the system. And so the real question, like in family court, if the perpetrator tries to raise immigration status in family court, one of the first things you want to do is help the court understand that it's not relevant to certain parts of the case. So it might be relevant. You might decide, because of you're trying to show the judge how he's using immigration power and control over, let's say, her immigration case to lock her in the relationship. You might decide that you want to make it part of your case. So it's relevant when the crime victim presents evidence of immigration-related power and control or immigration-related abuse, that he didn't file, I don't have my green card because he didn't file papers for me, or he filed them and withdrew them, or he's saying because he's telling me, I didn't report to the police, I didn't call the police for help, I'm trying to explain why I didn't, because he says that'll get me deported. Or, that somehow, the immigration-related abuse was part of the past history of violence. Those are all reasons why you might want to raise the victim's immigration status and show how the perpetrator was using it as part of power and control in your case. But even if you do that, you can still say, but however, it's not relevant to the core primary care determination. It has nothing to do with who's the primary caretaker of the child. Immigration status has nothing to do with an evaluation of parenting skills. It's independent of parenting skills. The perpetrator might say, well, I'm a better parent because I'm a citizen. Well, is that really true? No. And so you help the court see, you might not want to raise it yourself. You might want to just say, it's not relevant to parenting skills. It's not relevant to custody primary caretaker. It's not relevant. There's nothing in the best interest determination under Maryland law that would make immigration status relevant. And it's not relevant to, when there's a domestic violence case, the fact that in most, courts are supposed to consider the domestic violence case and decide domestic violence that's occurring and deciding where is best to place the child. And so we created like this myths and facts tool, because what we found is we did a overview of case law for decades on this and looked at every time immigration status came up. And we found these myths are kind of show up in the case law. One is the perpetrator tries to say immigration status is relevant because it means her deportation is imminent. Well, Most of the time, it is not imminent unless you have a victim with an open deportation order. There's no evidence, there's no reason to believe, and I'll give you the DHS data on this in a minute, unless she has a criminal history, that she's likely to be deported. DHS policies prevent the detention and removal of immigrant parents who are themselves crime victims. So there are protections against removal for crime victims that, if you're representing a victim, would come into play here. They might say, okay, she's, because she's undocumented or because she doesn't have permanent legal status, she's likely to flee the United States with a child if you give her custody. Also not true. The research that was done by the State Department years ago shows that actually the people most likely to flee with the children internationally are the people that have multiple entry visas, lawful permanent residency, citizenship in 2 countries, because they can travel freely back and forth from the United States, and they can take the kids and leave them there and see them there and never bring the kids back. Undocumented victims or any victim who qualifies for VAWA T or U can't travel freely in and out of the United States and is very unlikely to flee. And you'd handle this just like you'd handle any case where they say, oh, you've given custody, they're going to flee, get the passports, have the court do an inquiry as to what evidence is there that they're likely to really flee. Have they gone abroad and not come back in the past? Things like that. Sometimes they'll argue that the immigrant victim has no livelihood. And here's a place where you might want to reveal that she's in the process of filing for immigration relief and is actually, in a year will have work authorization. You have to decide strategically if you want to do that, or you could say, yeah, she doesn't have any livelihood because he didn't file her papers, and so you should pay child support, and we can take care of the livelihood issue through child support or through spousal support, because he signed an affidavit of support, which we'll talk about in a minute. And then there's the other lie that comes up in these cases is they say that the perpetrator will say, well, I'm a citizen or lawful permanent resident or visa holder, and if you don't give me custody, I can't file immigration papers for my child. Total lie. It is not, you don't have to have custody. If you're a parent and you're legally able, you're a U.S. citizen, you can file any papers you want for your child without regard to whether or not they're in your custody. This is the removal data you could share with courts. As you can see here, by and large, the people most likely to be most likely to be removed from the United States are people with pending criminal cases or criminal convictions, by far. And if you're working with a victim that doesn't have criminal convictions or a pending criminal case or an open, like they're actually got hearings before an immigration judge, or actually not even that, an order of deportation, there's really very little risk that that person's going to be removed just in the middle of it. And judges need to understand that. The other thing that's important is there are federal VAWA confidentiality policies and sensitive location ICE policies could be very helpful to you in structuring things like supervised visitation, because they tell you where ICE can't be doing immigration enforcement and why, for either against victims, which is the column on the left, or against anybody, which is the column on the right. So if you're working with a victim, a shelter, rape crisis center, programs that serving victims, family justice centers, courts are all safe. If you're working with anybody, so it's better to do exchange at a school or a place of worship than to do it at the police department. The local police department is less safe. Immigration enforcement could show up there, but they can't show up at these other places. This case has really good information in it about, I won't go into the whole story. This is a child welfare case in which they basically took the child, there was no language access at a hospital, and it spun way out of control, and this woman lost her kids. They basically didn't provide, she spoke Quiche, and they gave her a Spanish language interpreter, and they basically said, you know, she believed they said if your child, they gave her some medicine, if your child gets better, you don't have to bring her back. What they actually said was, if you don't bring her back in 2 weeks, we'll turn you into DHS for removal. And she didn't know, and kid got better. She didn't go back. They turned her in. She got arrested, detained, deported, served with notice. When in detention, the people didn't translate the notice. She didn't show up in court, and she lost custody of her kid. She lost parental rights were terminated. And the unanimous decision of the Nebraska Supreme Court overturned the ruling and basically said all parents and children, without regard to whether they're undocumented, detained, or deported, have the same constitutionally protected parent-child relationship and rights as anybody else. And it's always in the best interest to stay with their natural parent or be reunited to them without regard to that person's citizenship or immigration status, unless there's abuse or neglect or abandonment. And being, you know, abuse or neglect and being undocumented isn't abusive of your children. So it's got really good case law if you're litigating a case, and I recommend you look at it. The other thing is there's a detained parent directive that tells you how to get parents, if you have a parent who gets picked up and put in detention, DHS has to either bring that parent to court. They're supposed to bring the parent to court and not make them show by video. Now, obviously everybody's on video now, but they have to make that person available to be part of the case by video or in person. And if you ever have a case like this, just call us, and we have a direct line to the main person at ICE that makes sure people show up if your local office isn't doing it right. I've got not a lot of time, so I'm going to keep kind of going. Any questions in terms of custody issues or anything that you're seeing, questions that maybe I didn't address so far in the custody section? Okay. Okay, protection orders. Let's see where I'm going. Okay. So briefly, again, just highlights on protection orders, some basics, things, and we have lots of training materials on all of this and bench cards for judges and things you can look at. So as we talked about earlier, everything in your state protection order statute would be considered battering or extreme cruelty under immigration law. That the main points on protection order is some abusers will say, I can't agree, or I can't have a protection order issued against me because it will make me deported. Well, that's not true. Issuance of a protection order has no effect on somebody's immigration status. A finding that or a conviction for violation of a protection order, the protective provisions of a protection order, is a deportable offense. So if you have a victim where her perpetrator is violated, what I'm talking about is it's the protective provisions. So if he didn't bring the children back on time, back home for custody after visitation, that's not a deportable offense. If he abused her again, that's a deportable offense. Or if he stalked her, or if he, you know, something that's about the protective provisions. So it's a good idea for courts to issue Padilla advisals when they issue protection orders. We have information on that. The other thing about protection orders that's really important is that immigrant victims can really, really benefit from creative remedies, which include things like you can order the perpetrator not to turn her into DHS, to not call DHS or INS or well, there's no INS anymore, not call DHS or IRS or child welfare on the victim, absent a real emergency or a court order that allows them to contact them. They can, and I'll show you a second, well, I'll just do that right now. This is essentially a summary of an order that was developed by a DC Superior Court judge about 2 decades ago that people around the country have been using, and including in protection order proceedings to try to get at some of these issues. So that's there for you in the materials. But other things that can be used to deter international and local child kidnapping, you can get spousal support. Keeping health insurance can be important because immigrants don't qualify. If you're working in Montgomery County or PG County, which you're not, They have better access to health care for immigrants than other places, but generally these are some of the kinds of things you might want to think about including in your protection order. Again, we have lots of materials on these. Lastly, on divorce, the other thing to say is that divorce is not benign necessarily in immigrant families. It can cut people off from different forms of immigration relief. The best example is if you're working with somebody who got asylum and there's a divorce that becomes final before they've obtained lawful permanent residency based on their asylum. If they're the dependent spouse, let's say the asylum application was based on the abuser being harmed in his home country. If there's a divorce before she receives lawful permanent residency, she's permanently cut off from it forever and has to find another path based on her own harm in her home country to get there. Whereas if the divorce happens after the asylee gets lawful permanent residency, it has no effect on her. Refugees are different. So divorce plays a bunch of roles. And again, we provide lots of technical assistance and we have a divorce bench card you could look at to see how it affects. The next thing I want to talk about is affidavits of support. In cases where a U.S. citizen or lawful permanent resident sponsors a family member to become to get a green card, they have to file something called an affidavit of support. And those affidavits of support are essentially a contract between that individual, the sponsoring spouse, and the U.S. government and DHS saying, I will support this person at 150% of poverty for, until they essentially become a citizen or become a citizen. So for a long period of time. Now, why this is really important is this can get you the equivalent, they can get you a replacement for spousal support if spousal support's not available in your case, because you can enforce these affidavits of support in family court and divorce proceedings. The other thing that's cool about them is they have all this evidence. So if you order, let's say in a protection order, you order the perpetrator to turn over a copy of his file. So you can either get this file through a Freedom of Information Act request from DHS, which can take some time, or you can have the perpetrator turn it over in family court discovery or protection order, and it will have in it 3 years of tax returns. And what's really cool about this, judges, when I train them, love this part, because when the perpetrator filled out this form, he was bragging to the US government about how much money he made. When he's in your custody or support case, he's doing the opposite. So it's really good evidence of how much money he makes for purposes of child support and spousal support. And as I said, you can also enforce the affidavit and in fact, if you have a divorce case and you fail to try to enforce it, you could lose the opportunity. So it's important to go through and see if there's one in case you need to enforce it as part of your divorce case. And then we have the case law and the enforceability. I have a student who's doing a lot of research on that right now. On the child support front, I think there's a couple of key points that I want to highlight. Is that if the non-custodial parent is not a U.S. citizen or a lawful permanent resident, is an immigrant as well, and they may have someday a path for lawful permanent residency. In order to get their lawful permanent residency, every immigrant has to show that they're of good moral character. And in order to prove good moral character, one of the first things the Department of Homeland Security asks is, how many children do you have? And show us you've been supporting them. So it's a great tool for family lawyers if you're working in a case with an immigrant other parent, to say to their counsel or to say to them, look, if you pay child support through the court, you have a history. And if you ever go apply for naturalization or cancellation of removal or an immigration benefit, that history of child support you can use to show DHS that you're qualified for a green card. And so it's a way to kind of persuade opposing party to do this sometimes when they wouldn't. Works pretty well, actually. And it also provides, and so if you get a child support order for a victim who, you know, for your client, getting an order, even if the perpetrator may never pay it, shows she's of good moral character because she's taking all the steps that she can to support her children. And she can also use that court-ordered income as income to show that she's not going to become a public charge, even though she never received the money. So it's very interesting in that respect. Some perpetrators will argue, and there's great case law on this, that I don't qualify for work authorization, so you can't order me to work, so therefore I can't pay child support. Not true. If in fact the perpetrator or the non-custodial parent has any income, that income can be used to pay child support, and that paying it through wage withholding is super important for these cases. And there's some case law on this, and there's some case law of employers, usually who are a family member of the non-custodial parent, who won't comply with wage withholding orders, and they can be ordered to. There's really good case law on this around the country. So the last, and then there, I've got a few minutes left, so I'm trying to be wary of time here. So there's also information on how do you prove a non-custodial parent's income if they're working under the table. We have lots of information on that because you have to be creative in doing it. In a lot of these cases, you will have that happening. So the last thing I'm going to close on is, and there's much more of this detail in the webinar I did for the victim advocates, is that there's lots of benefits and services that your immigrant clients, foreign-born clients, qualify for without regard to immigration status. They can get legal services. They're entitled to, they can get divorce. They're entitled to language access to the police and the prosecutors and the courts and your assistance, etc. They can win custody and child support. They can file for public benefits that their children are eligible for without being asked any questions about their own immigration status or social security numbers. They're eligible for emergency shelter, transitional housing, school lunch programs, WIC, emergency Medicaid, which includes all COVID-19 treatment and testing. And they can get health care from community-based and community and migrant health centers sponsored by HHS, and then they qualify for VAWA as victims of crime. We have a map where you can look up in Maryland what all the range of benefits, because in addition to this list of benefits, whether they get TANF, subsidized health care under Medicaid, any of these programs, subsidized under Medicaid, child care benefits, public and assisted housing, will depend on the immigration status of the victim. And so what happens is we've developed, so if you go into this map and you click on Maryland, it will tell you by immigration status which victim qualifies for what in Maryland. And then we have a summary chart for you that you can look this up on. We have it broken down by VAWA and Medicaid and prenatal care. But I'm going to lastly just summarize what victims get, which immigrant victims based on which immigration status, and give you some tools here about what people can access in Maryland. And that is, so if in fact the victims have children who attended Maryland public schools for at least 3 years, or they graduated and have an equivalent from Maryland public schools, or like a GED, they could qualify for out-of-state tuition if their parents have paid taxes. And so people can pay taxes, they or their parents have paid taxes. Immigrants can pay taxes even if they're undocumented by using something called an ITIN number. It's a tax ID number that Social Security issues. In Maryland, the people that will have access to TANF will be VAWA self-petitioners, trafficking victims, people at the wait list, that 6 to 8 year mark under U visas, and children who received lawful permanent residency through special immigrant juvenile status. Childcare is the same. SNAP, which is food stamps, are available to VAWA children. So a victim or any of her children, including the VAWA application, 3 months after filing. Trafficking victims and lawful permanent resident special immigrant juveniles. The U visas don't get this. I talked about education. Healthcare, this goes through who gets child health care, who gets adult health care, and who has the eligibility to purchase health care on the exchange by immigration status. We discuss SSI. Maryland has a law that gives people, anybody who filed a tax return, Maryland driver's license, but the federally recognized one comes at work authorization for each of these case types. And lastly, I believe, second to last, they get so they have access to transition. All victims have access to shelter and transitional housing. VAWA self-petitioners 3 months after, or no, immediately upon filing, get access to public and assisted housing. So if they're living in a public housing unit where they're an abuser, and they file a VAWA self-petition, they can get they can throw him out of the house and continue to get the same amount of money based on their own eligibility. And we have lots of information to talk to you about how to do that. And there's more here. And then lastly, immigrant victims are exempt from public charge. So if you've heard things in the news saying you can't get them public benefits, because if they get the benefits, they'll lose access to immigration, becoming lawful permanent residents or citizens, that's not true. For victims it's not true for immigrant crime victims. So I'm going to close at this point. Any questions, burning questions that people didn't ask? I know I shouldn't do this at the end, but you never know.
Ms. Warlock?
Yes.
Hi. I'm with the Southern Maryland Center for Family Advocacy, and I want to first of all apologize for my technical issues this morning.
No problem.
This is going to be extremely helpful to us, the DV attorneys and the family law attorneys. This information has been incredible as we find that we have more and more immigrant victims that we work with. I have a quick question. I know it's at the end of it. So one of the things that we've noticed, and a lot of this information is sort of making a lot of sense in terms of things that we know we can look at to assist. One of the questions I have for you, and one of the things we find most often, is once we get the protective order for the victim, we see that there are pathways to citizenship. What would you advise our attorney to do to help kind of put that in motion? We have language barriers. For example, I had a whole letter that I went into Google and translated for a client so she would understand, you know, recommending that she contact CASA to get an immigrant attorney and that type of thing. But it's as difficult to navigate that process as the court system. So what can we do to best assist them to start that process?
Well, so first of all, we can get you, and Gwen will make sure they have this. We have like a screening tool. It's like a red flags tool, which sorts the difficult immigration cases from the ones that are not. And the cases, some of these cases where you don't have a client with a criminal history, you have a client who maybe entered the United States unlawfully, but everybody that qualifies for this did that at some point or another, or they don't have permanent status. So there's a lot, there are family lawyers around the country that are helping people do VAWA self-petitions and U visas. It's not, you have all the evidence because of your family case. Most of the evidence is there, and we have a trauma-informed interviewing tool, so Gwen, make sure that's on the list. We can give you that walks you through how to collect it. So there are cases that if you guys wanted to, you could do those cases if there wasn't an immigration attorney available, or you could, if she was able to get an immigration attorney, by you guys getting some confidentiality approvals in place, could work together so they don't have to recollect all the information you have already gotten. So that there may be, you know, there are things you can do in the family law case. If we have, one of the forms of technical assistance we provide is if you guys as non-immigration lawyers think you want to help this client get something filed and then go find the immigration lawyer to take it down the road, we can actually, my attorneys can review them and say, yes, this looks right, go get more of this, so we can help you do that. So, and I would encourage you, it's not, we have places in the country where there aren't even lawyers, and there are
Yes.
victim advocates that are helping people do this. So, you know, we can figure out how complex the case is. But one thing about the family lawyers is that you will have the evidence, because you're proving the abuse, you're proving the existence of the marriage, which you already, you know, or you're proving the, you know, the parent-child relationship, which are the same things you have to prove with a family court case. So yeah, we can, I think there's a lot you can do, and I think, and I don't think it's a big stretch. And we have like how-to kits, and we actually also have, we did in collaboration with a program called One Justice, and we should give them that link as well. If I didn't put it in, Gwen, is we have little online learning modules. It's like self-learning, 15-minute module here, 30-minute module there, how to fill out the form, how to do this, that. So you could, it's all online.
Yes. Yes.
So we have them, and you could just like take it, okay, I'm going to do this part, and you can call us and check in. So if you want to, on some cases that, as I said, where there's no criminal history, if you have a client who's like been going back and forth to El Salvador once a year illegally, crossing the border, that's a more complex case. Or if you have a client in deportation proceedings, more complex case. But that's not the majority of the clients you're going to run into. So hopefully that helps.
Okay. Yes, it does. And you're going to get those resources to us?
Absolutely.
We can look forward to, oh, okay, great. Thank you.
And we're going to get you a video of this. So we're going to send you a link with the PowerPoints, a video of this, and all the materials.
Okay.
And then that's why I was saying to Gwen, let's add this, let's add that, so she can check and make sure everything I was thinking about gets on the webpage.
Thank you, Gwen. You're great. Thank you so much for the work that you do.
You're welcome. Thank you guys for the work you're doing, and I hope this was helpful. Thank you.
It was. Thank you.
You're welcome. Bye-bye.
Bye-bye.
Thank you.
Thank you, Laura,
Thank you.
for convening.
Bye, Laura.
Okay. Trying to figure out how to